Think a will is set in stone. Think again. In the next few minutes, I am going to walk you through the exact process to contest a will and protect your inheritance. And believe me, this happens more often than you'd think. Statistics show that nearly 1 in 5 wills gets contested by a close family member. If you have valid reasons to believe a will is unfair or invalid, taking action could mean you receive a larger share of the estate, or in some cases, the entire estate. This isn't just about money, it's about honoring the true wishes of your loved one and ensuring fairness. So, let's break down when and how you can challenge a will. First, you can't just contest a will because you don't like what it says. You need to have what's called grounds, which are legally recognized reasons for a challenge. Let's go over the 4 main grounds. The first and most common ground is a lack of testamentary capacity. This legal term means that at the time the will was signed, the person making it, the decedent, didn't have the mental ability to understand what they were doing. To prove this, you need to show they didn't understand the nature and extent of their assets, they didn't know what they owned. Or, they didn't recognize their closest living relatives, the people who would normally inherit from them. Or, they didn't comprehend the consequences of the will they were signing, they didn't understand who was getting what and why. This isn't just about old age or forgetfulness. It's about a fundamental lack of mental clarity at the moment the document was executed. The second major ground is undue influence. This is a serious accusation. It means someone used coercion, threats, manipulation, or emotional pressure to force the decedent to change their will for that person's benefit. Imagine a caregiver isolating an elderly person from their family and then suddenly appearing as the main beneficiary in a brand new will. Or a relative threatening to stop providing care unless they are given a larger inheritance. Undue influence is about one person's will overpowering the free will of the person making the will. The key here is proving that the will reflects the influencer's desires, not the decedent's true wishes. Third, we have improper execution. Every state has very specific, strict rules for how a will must be signed and witnessed to be legally valid. These are called statutory requirements. If these rules aren't followed perfectly, the will can be thrown out. Common mistakes include not having the required number of witnesses present when the will is signed. In most states, you need at least 2 impartial witnesses who watch the decedent sign and then sign the will themselves. Another issue could be improper notarization, or if the signature on the will doesn't match the decedent's known signature. It might seem like a small technicality, but courts take these execution requirements very seriously to prevent fraud. And that brings us to our fourth ground, fraud or forgery. This is exactly what it sounds like. Fraud occurs when the decedent is tricked into signing the will. For example, someone might tell them they are signing a different document, like a power of attorney, when it's actually a will. Forgery is even more direct. It's when the will itself is a complete fabrication or the decedent's signature was faked. It could also involve someone altering a valid will after it was signed, maybe by inserting a page or changing the name of a beneficiary. These are criminal acts, and if you can prove them, the will is definitely invalid. So, you believe you have valid grounds. What's next? You need to follow a specific legal process. Don't just call up the executor and start an argument. You need to take formal legal steps, and you need to act fast. Step 1 is to gather your evidence. This is the most critical part of your case. Your claim is only as strong as the proof you can provide. If you're arguing a lack of capacity, you'll need medical records, doctor's notes, and testimony from healthcare providers that speak to the decedent's mental state around the time the will was signed. For a claim of undue influence, look for emails, text messages, or voicemails that show coercion or manipulation. Witness statements from friends, family, or neighbors who saw suspicious behavior can be incredibly powerful. For improper execution, you'll want to get the original will and compare it to any copies. Look for inconsistencies. The testimony of the witnesses who signed the will is also crucial. Once you have your evidence organized, it's time for step 2, filing a will contest petition with the court. This is a formal legal document that outlines who you are, what your relationship to the decedent is, and why you believe the will is invalid. You must file this petition in the specific probate court that is handling the estate. And here's a crucial warning. There are very strict deadlines, known as statutes of limitations, for filing a will contest. These deadlines vary by state, but are often as short as 6 to 12 months after the probate process officially begins. If you miss this deadline, your case is over before it even starts. You lose your right to challenge the will, no matter how strong your evidence is. Step 3 is serving the petition. After you file your petition with the court, you have to formally notify all the other interested parties that you have started a legal challenge. This includes the executor of the will and all the beneficiaries named in it. This formal notification process is called service. It usually has to be done in a specific way, like sending the documents via certified mail with a return receipt, or having them delivered in person by a sheriff or a professional process server. This ensures everyone is aware of the lawsuit and has an opportunity to respond. Step 4 is the probate hearing. This is where you, or more likely your attorney, will go to court. Both sides will have the opportunity to present their case. You will submit your evidence, the medical records, the emails, the witness testimony. The other side, typically the executor or the beneficiaries who want the will to be upheld, will present their evidence to counter your claims. They might have their own witnesses or experts. After hearing all the arguments and reviewing all the evidence, the judge will make a decision. This leads to Step 5, the possible outcomes. There are a few ways this can go. First, the judge could rule that the will is valid, and it will be upheld. In this case, the estate will be distributed exactly as the will dictates, and your challenge will have been unsuccessful. The second possibility is that the will is completely invalidated. If the judge agrees with your claim, for example, that the decedent lacked capacity or was a victim of fraud, the entire will can be thrown out. If this happens, what's next? The estate is then distributed according to the state's intestate succession laws, which are the default rules for who inherits property when there is no valid will. Usually, this means the assets go to the closest surviving relatives, like the spouse and children. Or, if there was a previous, valid will, the court might revive that one. There's also a third, middle ground outcome: partial invalidation. In some situations, the judge might find that only a specific part of the will is invalid. For instance, if one gift was the result of undue influence, but the rest of the will was fine, the judge could strike out just that one clause. The rest of the will would remain in effect, and the estate would be distributed accordingly. Now for a few practical tips to keep in mind. First, and I can't stress this enough, act quickly. The clock starts ticking the moment the estate enters probate. If you even suspect something is wrong, contact an attorney immediately to understand the deadline in your state. Second, hire a probate law attorney who specializes in estate litigation. Contesting a will is not a do-it-yourself project. It's a complex, evidence-heavy, and often expensive process. An experienced attorney knows the court procedures, the rules of evidence, and the best strategies to build and present a strong case. They can make the difference between winning and losing. Finally, keep a detailed paper trail of everything. If you notice suspicious actions before or after your loved one's passing, document them. Did someone suddenly isolate them from family? Were there abrupt, unexplained changes to bank accounts or beneficiary designations? Write down dates, times, what happened, and who was involved. This log can become invaluable evidence later on. Contesting a will is a major decision and can be emotionally draining, especially when you're already grieving. But if you truly believe that a will does not reflect the final wishes of your loved one, you have the right to seek justice. I hope this breakdown has given you a clear roadmap of the process. If you found this video helpful, please give it a thumbs up and subscribe to the channel for more content like this. And I'd love to hear from you in the comments. Have you ever faced a family dispute over an inheritance? Sharing your experience can help others feel less alone. Thanks for watching, and I'll see you in the next video.